order. Rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good evening, ladies and gentlemen. For those that are new to the procedures of the zoning board, the meeting is divided into two parts. During the first half of the meeting, we'll hold public hearings on all of the applications before us. We'll take them in the order in which they are listed in the agenda. And if you would like a copy of the agenda, it's available in the tray right there by our counsel's desk. During these public hearings, we'll ask the applicant to come forward and to give a very brief kind of summary of what the application is about. We don't need to go into a lot of detail at this level since we have your application before us. At that point, members of the board will be able to ask questions about the application. When the board members have finished asking their questions, the floor will be open to anyone from the public who would like to address that application, but that application only. For those that wish to comment on the application, we will ask you to come forward to give your name and to be sworn in. This is important because the zoning board is a kind of quasi-judicial hearing, and all of the testimony must be sworn testimony. I would also ask everyone, and that includes members of the board, to be careful to speak into the microphone. It's important that we have a good audio record. And as many of you know, our meetings are televised, and there's nothing more frustrating than watching a meeting where mouths move and there's no sound. So help us out and help out our viewers. Both of them. Who knows? Okay. Once the public hearings have been concluded, we will then return to the top of the agenda for the deliberation phase. And during this part of the meeting, there's no further input from the public or from the applicant, although you are obviously welcome to stay and listen to our deliberations. I would just note that we're first of all welcoming back Carmen Bucky.
Good to be back.
Yes, good to see you.
Thank you.
Unfortunately, one of our regular members, Art Grace, is ill, and our alternate, Paul Leahy, will be filling in for Art. In the event that there are any recusals, Phyllis is the second alternate, and she will fill in as needed. Okay. With that, let's turn to item number 1 on our agenda, Leanne Lee, 81 Buckingham Avenue. Good evening.
Good evening.
And if both of you would state your names and be sworn in.
My name is Vincent Catalano. I'm the attorney for Leanne Lee.
My name is Ty Van Lee.
Mr. Catalano, Ms. Lee, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
I do.
Please be advised that you are under oath, and any false statements made by you are subject to perjury pursuant to the laws of the state of New York.
Okay.
So we were last here in October on this issue, and my recollection is that it was suggested to me that what had to happen before we went any further is I had to go to the highway department and get at least some input from the highway department regarding the driveway, and most significantly, the telephone pole that is located in the middle of the driveway. So I've done that, and I've discussed this in some detail with Mark Pfeiffer, who is here tonight, and I'd like him to come up, if that's okay, and
Please.
discuss what we've,
Please.
what we've come up with as a resolution to that issue.
That microphone may be working.
Okay, we can share that.
Okay, fine.
Either way.
Okay, and your name, sir?
Mark Pfeiffer, Town of Poughkeepsie Highway Superintendent.
Mr. Pfeiffer, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please be advised that you are under oath, and any false statements made by you are subject to perjury pursuant to the laws of the state of New York.
Okay, so. I don't.
Yeah, go ahead.
Mr. Lee, he's over on Buckingham Avenue. He paved his driveway, is what happened. He doubled the size of his driveway to make more access for it. Did not come and get a permit. I didn't know that it happened. After the driveway was paved, there's a telephone pole dead in the middle of it, which doesn't work. So he came in to obtain a permit for me, and I said, no, you can't have one. I said, if you had came to me first, I would not have given you a permit for this driveway. It would not have been issued. So now the issue is that there is a driveway here. He has a circumstance where he wants to be able to park more vehicles in the driveway off the road, which that part's a good thing. So I tried to do my best to come up with a solution to make it work for everybody, to approach to your board, and it's kind of at your pleasure. This is what I came up with, and it's more at your pleasure whether you think that this is a good idea, bad idea, if we want to grant this, because I don't know what would happen in the future for. So you have a drawing in front of you, which I suggested that the telephone pole was back 4 foot off of the street. So I suggested that we make that telephone pole a center point and go 4 foot every direction around the telephone pole. I also had him put in a retaining tie so that it would raise up a little bit, not in the front so the plow doesn't hit it, but around it so that it wouldn't just be driven over and become mud. I also suggested that they put some shrubs in there, to kind of protect it, because if someone hits the pole, pulling into the house, we don't want to be responsible for this, especially if we're going to grant a variance for it. So I'd also suggested that there be writing in this variance that would protect us, that if someone living in this house crashes into the telephone pole, that we're not responsible. That's basically where it was at. So that was my best solution, other than not making him remove the driveway. I tried to come up with something that would hopefully make everyone happy, but I don't know if it doesn't, and if it doesn't, it's the pleasure of the board.
Okay, thank you. I guess I'll just go around. Christine, you have any questions?
Questions?
Betty?
Can you remind me again why it is that you needed a driveway that wide? I have 1,000 notes on here, but none of them say why you needed it that wide. How many people live in the house?
3.
3. And does anyone use the garage at all, or?
Well, the garage you can't go in because the garage is only not even only 7 feet something, the height. The car can go into the garage,
Oh, it can't go into the
No,
garage. And Mark, can you tell me why putting that planter around the telephone pole, why that helps? Is it so that people wouldn't knock it down? Is that the idea?
Yeah, I was just trying to protect someone from crashing into the pole. But there's a wall, as you pull in, there's a unilock wall on the right. It's a pretty tight space. So I think it's possible that you could crash into the telephone pole. They only have I think there's about 13 feet in between. So we're going to narrow it down 4 foot. So they're only going to have about a 9-foot pass to go in that driveway. A car's probably 6 foot wide. It's going to be pretty tight. And I don't want the town to be responsible if somebody coming home at night crashes into that pole, because
Right.
it's not what we intended. So I'm just trying to protect us.
So how many cars before you get to the telephone pole and the planter that goes around it, how many cars could you fit in there? Do you think 4?
No, before I blacktop it,
No, right now.
Be-
right now,
Yeah.
Right now, it's like, yeah, 4 car.
4, 2 on each side, because the driveway kind of has 2 sides, so it would be 2 on each side.
Yes.
Okay, I have no more questions.
Okay, Tony?
The elevation of the tie is only a few inches?
Well, that's what we had suggested. I would say on this, in the front, out by the street, I wanted it flush, with the street, and then, it can raise up on the sides to maybe, 3-4 inches, so that, because if we don't have something there, I think the car is just gonna drive up through it, and it's gonna turn to mud. It's not gonna stop them from using that or protecting them, and so I think it'd be raised up a few inches just so it defines an area. So between the ties, so it's really 8 foot between the ties. It's an 8-foot section.
So the ties weren't put there to protect the pole?
Well, to protect the pole and to not have it become a mud hole.
Okay.
Because I think if there wasn't there, they would just drive over. If it was lawn, you're just gonna drive over to make it easier. And I want to define that it's not driveway.
You okay?
Yeah.
Okay. Yeah, I also wanted to pick up on that. You really need it flush with the pavement in the front? Isn't it set back enough so that if the plow is,
I think it's 4 foot from the pole to the road, so if you, and
Oh, I
his
see.
suggestion was that we do 4 feet all the way around.
yes.
So I don't, if you have it elevated, aren't you gonna run the risk of the
The
plow
plow.
running into it?
Okay,
Yeah, we'll wipe it out with the plow. There's no doubt.
okay. I'll take your word for that, yeah. All right, but, and I noticed on the drawing, it said something about it was gonna be, it looked like it was gonna be 2 inches all the way around. So we need to just basically correct that.
I mean, it can be, I didn't have a certain height, but as long as it's up enough where the car's not gonna ride over it.
So it wouldn't be 2 inches in front, though, is what you're suggesting, maybe?
Yeah.
Yeah.
But I would kind of suggest that just, we can, I don't think we undo any formality here, but an understanding that it's going to be pretty much flush with the pavement in the front. But I would suggest it go up at least 4 inches in the back.
Yeah, they're 6 inches thick.
The
if you use
ties.
a tie, so I would say like bury half of it. So it's not gonna flop right out of the ground. So
Right.
It was secure in there, so half and
Okay.
half.
Well, but enough so that people see it and feel it. if
And then
they-
some plantings inside.
Okay. And, okay, and I was actually gonna, you read my mind, that as part of the conditions, that there be some plantings, flowers, shrubs.
Right.
Again, to make it visible, but also to kind of break up this big expanse of asphalt.
Sure.
Which is, when you look at the code, one of the reasons for not allowing these huge driveways is we don't want to create, situations where yards are completely paved over and look like, runways. Okay, and then you'd be agreeable to some condition that suggests that the town is not liable for any accidents that might occur.
Yeah, that was something that Mark and I discussed right from the beginning, and that's understood.
Okay, all right. So we will probably add a provision to that effect. Larry?
No questions.
Okay. Paul?
Can you tell me, before you put the addition on the driveway, where was the telephone pole in relation to the existing driveway?
Right,
There was was it just a dirt driveway? Is that what you're asking, Paul? Like, where was it in relation?
Well, there was a driveway there first, right?
What was it? Was it gravel, dirt? What was it?
it's nothing, just right on the dirt, right next to the, the existing driveway and the pole sit next to the driveway right there. Just
You know where the
close to
pole
it to
is?
the-
Was there a driveway there before?
Yeah,
So how much space, well, let me ask, when did the telephone pole get put in?
excuse me?
When was the telephone pole installed?
Oh, I purchased the house a couple of years ago, that telephone pole's been there,
Okay. And so how much room, where the pole is now, That's how much, you were able to negotiate the driveway before?
Well, before the existing driveway there, they got a curve like a retaining wall right on the right side.
Right.
When you come in, they knock it out. They bear them out like this. It's only the 13.5 inches from here to here. But when you go in, it's only like 10 inches. When you go in, only like 11 or 10 or 11 inches wide, you know, feet wide.
Okay.
But the outside, when you come from the street, go in, they just make them out a little wider so you can turn in. But if you come, so it's really hard to turn in with it because of telephone pole right there, you know. We got to make a real wide turn to go in, you know. But then, you know, when I park the car there, when we come home, when we go in, sometimes we can't go in. My wife, we got to park on the mud. You know, we kill all the grass and all the mud, you know, and spinning around. A lot of people, they complain about it, you know. So, you know, and that's why.
On the other side of the pole.
Yeah, on the other side of the pole before the blacktop, before I end in the blacktop, you know.
Okay. And Mark, do you know, are there any utilities underground near that pole?
I don't believe so. Everything is overhead on the pole. I don't know, there may be gas, you know, but so before they cut the blacktop, they're gonna have to put the dig, you know, they have to call the safe dig in and do that section of it. So, you know, it's a situation that's there, so I'm trying to make the best of it, if it can be made.
All right, thanks.
I have a new question.
Yeah.
Do you live in the house? Do you reside in the house?
No.
Oh, because that's, you were talking about your wife driving in on the mud
Well, when I purchased the house, yeah, we is there, you know, but we don't, when we move out, we don't stay there. So I rent it to the people. I rent it out to the people, you know, but the people that work for my wife, you know, then there's the same thing. I go in, they can go in. I just make, you know, I thought, I don't know, I added in to make the, you know, to make it look good, because every time I go over there, you know, they run to the mud, they spit in the mud everywhere, make the hole everywhere, and even the people across the street, they tell me that, you know. They say, you know, try to tell your neighbor, you know, to keep the, you know, don't go into the grass and stuff, you know. Then when it rains, sometimes rain and stuff, you know, they just run into it, you know. That's why I add in, you know, if I know I can't do it, I'm not gonna do it, you know.
Okay. Carmen?
Yes, did you say earlier that you cannot put any car in that garage? It doesn't fit?
No.
Is that because
Well,
the height of the car?
when I purchased the house, looked like that the people there before looked like they raised the black top from the garage. When you go into the garage from the black top, you can see the black top about 6 inches height. When you walk into the garage, you step down like 6 inches down. Look like the man was there before when I purchased the house from him. He did it, you know.
Okay.
He did it. That's why when you walk in, when you have to walk your foot, like you drop into the, you know, like you drop in, you know, when you walk into the garage. And that's how high, how deep the garage is, and the blacktop about that high, like 6 inches, you know. And that's why the car cannot go into the garage, you know.
Okay, so we're saying that at no time can a car fit into that garage?
Well, fit in, but you can't back it out because it's about 6 inches high like that. You know, when you back it in, you're gonna, you know, you can't come out, and then you put a little ram on it, you know.
Okay. Now, you plan on the driveway to the left, the wider driveway. You plan on having 4 cars there?
I don't plan to have a 4 car in there, but just, you know, you know, 2-3 car and whatever.
Okay.
The house is currently rented to a man and a wife and their daughter.
Okay.
They're an older couple. I guess they're in their 50s. That doesn't sound so old to me anymore.
Just be careful, counsel.
I would strongly suggest that you
what can I say?
rephrase that.
Yes, the words were coming out of my mouth. Anyway, so, and a daughter, and she's in her 20s, and they have 3 cars.
Oh, okay.
It's a 2-bedroom house. I
Right.
think it's about 1,100 square feet. It's not a big house.
Okay.
So, and the last people that rented it was a woman who worked for Leanne Lee, and it was, I think, they had a small daughter, and it was the husband, so.
They were an older couple then. Okay, thank you.
I'm not going to say anything else now.
Okay. Any other questions from members of the board? Okay, if not, is there anyone in the audience that wishes to address the application 81 Buckingham Avenue? Okay, seeing none, is there a motion to close the public hearing?
So moved.
Second.
All in favor?
Aye.
Aye. Recusals? Okay, thank you very much.
Thank you.
And thank you, Mark, for being here and clarifying it. Okay, item number 2, Anthony Leo, 11 Spring Street. I understand at the request of the applicant, this to be adjourned to our May meeting. What date is that?
May 11th.
May 11th, okay. So is there a motion to adjourn item number 2 to May 11th?
So moved.
Second.
All in favor?
Aye.
Aye.
Opposed? Recusals? Okay. Item number 3,
Mother's Day.
John and Maria Rautenstrauch, 7 Old Farms Road. In checking my notes, did we close that public? So this is a closed public hearing.
Oh, we did? Because I told Sandy we just adjourned it.
And Lisa and I listened to the video.
Oh,
Okay.
We actually did close the public hearing. However, in the interim between the last meeting and this meeting, we've received a lot of information, and I understand that there are people here that would like to speak. Since we noticed the meeting as a public hearing, there's no legal barrier to continuing or reopening the public hearing.
Right, okay. So I move that we reopen the public hearing for item number 3.
so moved, or second.
All in favor?
Aye.
Aye. Opposed? Okay, so, the is the applicant here? So we should begin with the applicant, and then we will hear others that are interested. Okay, so if each of you would state your names into the microphone, please?
Maria Rautenstrauch.
John Rautenstrauch.
Robert Lutz, DBS Remodel.
Okay. Do,
Mr. and Mrs. Rautenstrauch and Mr., what'd you say now? I'm
Lutz.
sorry. Lutz, I was listening to the chairman, I'm sorry.
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be advised that you are under oath, and any false statements made by you are subject to perjury pursuant to the laws of the state of New York.
okay, I don't think you need to repeat, we have your original application in front of you, so I guess what we're interested in, is there anything new that you wish to present to us?
Well, yes. I don't think that there was enough, or even maybe nothing said about this last time. But over the last 2 years, I've had 3 major orthopedic surgeries. And so one of the reasons for doing this remodel, or the main reason for doing the remodel, is to be able to make both of the bathrooms handicap accessible. As it stands right now, when I came home from 2 months in the nursing home and 8 months of physical therapy, I couldn't get a walker through the door into the bathroom, and we weren't able to get a wheelchair through there. So the proposal is to just take that first bathroom and take the second bathroom and combine that into one and move the common bath back. But it's primarily because of the fact that it's a necessity for me. John has done everything. I haven't even been in the cellar for the last 2 years because the laundry is down there and I can't do the stairs anymore. So we'd like to expand the bathroom, make it handicap accessible, a curbless shower large enough to actually move a wheelchair into if you had to, and also the second part of it, which is the 10-foot extension, will have the accommodations for the washer dryer. So the primary purpose really is medical necessity for me. And I didn't speak to that much because I feel pretty guarded about having my privacy, but felt it was necessary to make this better known.
Okay, thank you. Before we go any further, I should just note for the record that the zoning board has received a number of letters, 1, 2, 3, 4, 5, 6, 7, from residents in the neighborhood. I believe all of them, in fact, are on Old Farms Road. And all essentially saying they're either in support or don't have any objections to the proposal. So I won't take the time to read them into the record, but they will be part of the written record.
I also have 2 letters from my doctor about the medical necessity. Would you want a copy of that?
I don't believe that's necessary.
Okay.
Your testimony, I think, is pretty clear. Okay, Christine, any questions?
No questions.
Betty?
I have no questions.
Tony?
I have no questions.
Okay. I do anything.
No questions.
Paul? Carmen?
No questions.
Christine?
Phyllis, no.
Phyllis? I have to do that once a month. Once a month. Good for me. Okay. All right. So there are no questions. Is there anyone in the audience that wishes to address the application at 7 Old Farms Road?
Sir,
Yeah.
could I make a couple of comments? There were some objections last week from one of the, last month, about
Yeah.
some of the objections, and I'd like
Okay.
to discuss that, some of the objections. One of the objections was to try to put it in the back. We've provided additional pictures showing that we do have the screen porch, and, the deck and the screen porch right next to it. I think it was commented that we said that we had a deck across the whole house. I'm not sure where the discrepancy came in, but the screen porch is directly, it's in the middle of the house. And if we had to take both those down, it would be very cost expensive to do that. One of the other items was the driveway, the backing out from number 5. There was in the packet that you got from number 5's lawyer, it said that one of the key items in that whole package was the development requires 40 feet of setback, and I believe someone from our builder's office talked to Miss Lane at the office, and they found out that the town only requires 30 feet, so there should be enough. I mean, we're 10 feet more than required by the town, so we don't think that's an issue.
Okay.
What was the other issue?
Just regarding the car.
The other one was regarding the character of the neighborhood. I've talked to, sorry, sir. I've talked to a bunch of the neighbors, and I believe that's basically what you said from the neighbors had written in, that they didn't see any issues with the proposed changes. We're basically running if you go to the side of the house, north side of the house, going straight out toward the street, we're not going any closer to the property line. And the reason why we have the differences of the extension is because where we're putting in the laundry room, we don't need to push it out that far. We try to keep the aesthetics the same because we're trying to keep the roof line the same.
Okay. Yeah. Now, in the packet that you submitted, which is part of the record,
Okay.
there, the floor plans and the picture of the back, it was very helpful. So,
Okay.
there are no other questions from the board. There's no one in the audience.
There is.
Yes, ma'am? If you wish, you're going to have to come up and be sworn in.
Did you have something you wanted to add, Bob?
John covered all the.
You covered
Is it?
We could have covered it.
Okay. The microphone here should be working. So if you take that, it's portable, you can take it out. And it should turn on, let's see. Okay, so state your name, please.
My name is Dr. Aruna Bakru. I'm the neighbor at 5 Old Farms Road that's affected by this application.
I hope I don't mess up your name, Dr.
Aruna Bakru.
Bakaru. Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please be advised that you're under oath, and any false statements made by you are subject to perjury pursuant to the laws of the state of New York.
Okay, go ahead, please.
Well, I sympathize with Mrs. Rosenstroch, because situation. However, they're basically moving in on me. They're only 14 feet from me, and if they want, they can come up with a million reasons why they need to move in on me. And if they want to move next to somebody else, they could come up with a million reasons why they need to do that. The basic point, as the application that my lawyer submitted stated that it's not like this is the only possibility. Their builder themselves stated at the last meeting that they could do it at the back, or they're 21 feet from the other neighbor. There are areas like the laundry room and so on and so forth, and even the bathroom could potentially go to the back. So, the other people that submitted all the letters in support, they don't care because they are not affected. I am, because I'm the neighbor that's affected with this, build out. I am not aware of any other house on the street that does not comply with the 40-foot setback. So I don't know if there is one or not. But in the covenant, the restrictive covenant that was set up for Hagentown, it said that there should be a 40-foot setback, and that was specifically for Hagentown. So that's what I wanted to say.
Okay, thank you.
From our drawings, and it shows that we'd have more than the 40-foot setback. I don't remember exactly what the number of feet is, but it's more than 40 feet.
Okay.
The point of trying to put it on the other side, we have a picture of the garage. I can show you. I have a picture of the front here of the house completely, and the garage is on the right-hand side. So if we had to try to put, you can't put a bathroom on the other side of the garage. And then we'd have to come in with, because if it's discrepancy of if we have 20 feet or not over there, but even if we did have 20 feet and we're trying to build out to the right of the garage, then we still have a problem because we still got to come to you anyways for a variance to put anything on the other side.
Right.
Is Ms. Bakaru number 5?
Yes. Yes, ma'am.
Okay.
Okay.
She's on the side where the construction is. And also the driveway is a lot higher from this.
Okay, any other questions? If not, is there a motion to close the public hearing?
So moved.
Second.
All in favor?
Aye.
Aye.
Opposed? Okay, so thank you very much.
Thank you.
Item number 4, U-Haul at 2175, 2185 South Road. Okay.
Thank you.
Okay.
Yeah, there we go.
Okay, would you state your name, please, and be sworn in?
Jessica McEwen.
Ms. McEwen, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be advised that you are under oath, and any false statements made by you are subject to perjury pursuant to the laws of the state of New York.
Okay.
Okay, good evening, and I believe you've distributed to the board members
Some revised plans.
a revised proposal for signage for the U-Haul storage. Okay.
Yep. We have scaled everything down considerably from what we were originally asking for.
Okay.
prepared for battle. I said all the way up and down 95, I looked for U-Haul buildings, and no one had those boxes.
Not in this area yet. This is the
Not
first in
even
this
down
area.
anywhere close to 95.
I think the closest is Connecticut.
Oh, I didn't
with
go
this
that
other-
way.
Yeah, they just put in 2 new locations in Connecticut that have these.
I like your new plan.
I had a lengthy discussion with them and told them that this is the right thing to do. We already got the permit, we scaled down, took the boxes, we're at 100 square feet for the main building sign, which we just got our permit for last week. And we got rid of the directional altogether for now, and we scaled down the other 2 signs from 60, it was actually 64 square feet each to 40 square feet each side, which you'll see in the pictures,
Okay.
what it's gonna look like.
So let me check with the staff here. So now the application is really for
80 square feet.
a single variance
Yep.
that would allow 2 additional wall signs of 40 square feet each.
Yes.
Okay, and so the other 2 provisions are
Off, yeah.
dismissed?
Yes.
Yes, okay. Okay, Christine?
No, I'm looking at the picture. I don't have any questions.
Okay.
Thank you.
Betty?
No, I'm happy now.
I intend to do that, never mind. Okay.
That's
Good thing.
important, Betty, that you be happy.
It's a good thing, yes.
They made it smaller?
I wanted her to be happy specifically.
Okay. Tony?
No questions.
Okay. No, and I want to thank you for really rethinking this. Having the main sign fit the code, perfect. And given the size of the building, the 2 additional wall
Yeah.
signs, and I think it's much more consistent with whatever the other things that are going on down there. Okay. Larry?
No questions.
Paul?
No questions.
Carmen?
Yes, and I want to thank you as well for working with the board.
Not a problem.
Okay. Phyllis?
No question.
Okay, anyone from the audience that wishes to address the U-Haul application 2175 South Road? Hearing none, is there? Oh, and the county has simply said this is a matter of local concern, so they have no issues. The one last thing, somewhere, is there an environmental form? Okay. Okay, good, because it's an unlisted action, so we'll have to do that. Okay. Is there a motion to close the public hearing?
So moved.
All in favor? Aye. Opposed, recusals? Thank you very much.
Thank you.
Item number 5, Keith and Debbie Hofnagel, 131 Violet Avenue.
No, I have New England Realty.
Okay, so if each of you would just state your names, be sworn in, please.
Keith Hofnagel.
Enrique Pinello?
Mr. Pinello, Mr. Hofnagel, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Please be advised that you are under oath, and any false statements made by you are subject to perjury pursuant to the laws of the state of New York.
Okay.
Okay, let me see, you have submitted several additional pieces, and I'm sorting through.
I was advised by the attorney to bring in financial information, which I did for you to look at.
Okay, and, okay, I believe that there are, from the last time that we discussed this, and the our attorney and staff can correct me.
Well, I-
There were two main issues that were unresolved. One had to do with
Where is he?
the circumstances surrounding the former use, which I believe had lapsed, and now the process of taking up again a restaurant use in a residential district. And the second was information establishing that without this use, there would be a severe hardship.
It is, and it would be. And the paperwork I gave you is rough numbers of what we purchased the building for, what mortgage, taxes, insurance, things of that nature are. And we purchased that restaurant, we started looking at it almost a year ago, of course, was to rent it out and make a profit. If we're unable to do the restaurant, it's in front of you, it's just definitely not going to happen. All the permits and the work that has been done in that building were started on the paperwork I gave you quite some time ago. I gave you copies of all the certificates of occupancy. I gave you copies of, there was electrical work, plumbing work, things of that nature that were all completed, and the final inspections were last year in August. Part of the purchasing of that property was to make sure everything was taken care of through the town building department, and there was no open work order or things of that nature. Also purchasing the property, part of the agreement was that we could use that building as a restaurant. And, of course, in our contracts with the attorney, they said yes. What I'm getting at is just, we bought that with the intention of renting it out from the beginning. It wasn't something.
As a restaurant.
Correct. It wasn't something we said, oh, let's decide in December to do that. The other information I gave you, I might have given it to you last month, that the town did issue a permit. The permit copy I don't have. I do have the receipt here. The payment was $200, and the permit was, that was given on December 2nd of 2014. The work, he also received a Dutchess County Health Department permit, and that was back in December as well. The investment in that, just to rent it out, was about $37,000. And, of course, he put in his own equipment and updated counters and tables, things of that nature, and that's over $70,000. So the intent was there to keep it going. The stop work order, it said, that was on January 2nd. Permits were required, which he did have the permit to do that. He did pay for the permit to do that. If I'm unable to get of course, the zoning, then there's more issues, so.
Okay. I think before we go to questions, I'd like to ask our attorney to kind of clarify what the law is on the issue of the use and the continued use of a piece of property.
During last month's meeting, the board asked me to take a look at whether it was possible for this applicant to continue this use or recommence this use, given that more than 12 months had passed. And so during the month, I did research, and the board has before them a memorandum. There is a line of cases which allows an applicant to use as an exception to the self-created hardship rule the fact that they made an expenditure in reliance on a building permit that was issued by the town. So in this instance, the applicant has presented evidence that the town issued the permit and work was commenced both by him and by his tenant. And if the board found that that was done in good faith by this applicant, it can use that as an exception to the self-created hardship rule, which would otherwise bar this as a use. So obviously, all the other criteria still need to be met for the finding of a use variance. But in this instance, this narrow exception allows the board to consider this and permit the use if it finds that the applicant acted in good faith.
Okay, thank you. And thank you for the research, and all of you have the memo in front of you. But I thought it was important that we hear in open session and then not in some sort of closed session to just make it absolutely clear what the various criteria are. Christine, any questions?
No questions.
Betty?
No, I think I'm good.
No questions.
Okay. Let me, okay, let me just go ahead. Larry?
No questions.
Okay, Paul?
Yeah. I recognize that you purchased the property with the intention of using it as a restaurant, but a use variance requires you to show that you can't get any reasonable return from any of the permitted uses. So what analysis have you done for use of the property for any of the permitted uses within that zone?
Permitted use would be childcare, and I don't do childcare.
Well, let's see what all the permitted
I
uses.
mean, I have served on the board of an agency that did childcare, and the building requirements for running any kind of a daycare are very extensive. Your building simply isn't big enough.
It's not big enough, and the amount of work that would have to be invested in that, it wouldn't be worth it.
There's actually a big one, right, like a quarter of a mile away.
Yeah, not even, yeah, you're right, there is.
Is that the only analysis that you did?
Yes.
Okay, that's all I have.
Okay. Carmen?
I have no question.
Okay. Phyllis?
No questions.
Okay. Okay, what I want to do is come back to the code, which specifies the criteria that we have to meet, and so I just want to make sure that we've touched all the bases here. Okay, no use variance to be granted by the board without a showing by the applicant that zoning regulations and restrictions have caused unnecessary hardship. Okay, and okay, in order to prove such unnecessary hardship, the applicant shall demonstrate to the zoning board of appeals for each and every permitted use under the zoning regulations for the district where the property is located. So your argument is that all of the things that are listed out are just not feasible.
Correct.
Okay. That the applicant cannot realize a reasonable return provided that lack of return is substantial as demonstrated by competent financial evidence. Okay, and so your position on this, substantiated by the material you have sent, is that the amount that you've invested to this point and what the
amount I invested, of course, is for a restaurant, so that would be thrown out the window. To do anything else in there, at the last meeting, to redo the building that's there now, remove the parking lot, because I think it could go residential. Well, I don't even think it can go residential because there's already one house on that lot. There's nothing else I could use that building for.
Okay, and to not use it would be
As I said, I'd have to tear it down because the taxes are too high on that building there.
Okay.
I mean, I'm not saying I want to do that, but
right.
I can't think of anything else to use, storage or whatever, but it's expensive storage.
Yeah, okay, okay. That the alleged hardship relating to the property in question is unique and does not apply to a substantial portion of the district or neighborhood.
That's absolutely so. That parcel is so unique within itself. First of all, it has a living facility, the house,
Yes.
and the restaurant on the same parcel.
Yes.
That have been there and being used as a restaurant since at least 1960, and we established that already.
Yes.
So I don't think there is any other parcel
Okay.
within the town that has that same framework.
Okay. That the requested use variance, if granted, will not alter the essential character of the neighborhood.
It will not.
anyone that lives there, except for maybe some really old people, don't remember it any different. It's always been like that.
And there's been no complaints on people living there. I know we live right near there also. And the biggest question is, when's it going to open? They're looking forward to it opening, and Betty going back to work there.
Yeah, good luck with that one.
Okay. And finally, that the alleged hardship has not been self-created, and we've already addressed that, so, okay. All right, any additional questions from the board? Is there anyone in the audience that wishes to address the application at 131 Violet Avenue? Okay, hearing none, is there a motion to close the public hearing?
So moved.
Second.
All in favor?
Aye.
Aye. Opposed? Recusals? Okay, thank you very much.
Thank you.
Oh, and, okay, and Andy assures me that the county has said that is also a matter of local concern. Okay, I'm getting ahead of the paperwork here. Okay.
Thing about that.
Item number 6, Paul Suozzi, New England Realty Group. Realty and Reality too. 92 Fairview Avenue. Okay, good evening, folks.
Good evening.
You'd each state your name and be sworn in, please.
Paul Suozzi.
Theoni Stamos-Salato, counsel for 92 Fairview Avenue.
Damas Salato is the last name?
Yes.
Okay. Ms. Damas Salato and Mr.
Suozzi.
Suozzi, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Please be advised that you are under oath, and any false statements made by you are subject to perjury pursuant to the laws of the state of New York.
Okay, I believe the last time you were here, you left us a thick packet of copies of leases and some statements from tenants. Correct?
Affidavits from the tenants, correct.
Okay, and we all have those. Is there anything further you'd like to add to the application?
Well, I believe there was a request for the police, I guess, blotter entries for the location with regards to any violations or any complaints. So we do have copies for all of the board members. I can.
Oh, okay. If you just want it, and she'll pass them along.
And it's my understanding that the police looked back a few years from 2012.
2013, well, Mr. Grace asked for 2013, 2014.
Okay.
And the police officer I spoke to went all the way up to the present day.
Okay, good, thank you.
And this was all that was there.
And there appears that there was only one complaint, and that there was a warning issued, and there was no violation or anything that resulted from that.
Okay.
The police officer said that there was no loud party. It was just two guys were in the backyard.
Okay.
Playing their radio. This occurred, I think, right after they finished their final exams, and they probably were a little excited to be done for the semester.
Okay. Okay, I think also just to clarify to everyone that what's being requested here is an interpretation, a determination that the occupants of 92 Fairview Avenue are the functional equivalent of a family as defined in section 210.9 of the code. So the kind of narrow issue before us really has to do with this notion of the definition of family as it is in the code, and that some of these others are related and possibly relevant, but not central. So I just wanted to make it clear to everybody that, you know, the police activity is not the central issue here. But thank you for pursuing that.
This also didn't occur with the present tenant.
Okay.
This was a previous tenant.
Okay. Christine, questions?
No questions.
Okay. Betty?
What about this letter from Sarah dated November 26th that says that, that they were going to reduce the occupancy of the dwelling?
Correct. We, initially, we asked, well, my client was going to reduce the occupancy, figured it was a more cost-effective approach. However, that was not possible. The tenants, I think we brought this up last time, the tenants basically refused to vacate. They had a valid lease. I supplied the board with copies of their leases. It is a yearly lease, and they did get counsel. So at that point, we were in a position where they were refusing to vacate. So in turn, we filed for the interpretation. But some of our other arguments, and I understand it's not the board's primary focus, but we do have other valid grounds. For instance, it was in our initial application. We believe that this property should be grandfathered in. This property predates even zoning laws. It was built prior to the zoning laws. As far as my client knows or believes, the property could have been rented in this same exact manner way back then. Marist was around prior to when this house was built. So as far as we know, could have been rented in the same manner. It is a two-family dwelling. When he purchased it, it was rented 6 on one side, 4 on the other. The way the units are constructed, he could, with minor alterations, change that. So that's another issue that we'd like to, I guess, discuss with the zoning administrator, because that was never an option. So at this point, we'd also ask that the meeting be held open so that we can look into and provide the board with additional evidence. We're going to try and locate the prior owner that my client purchased the property from, to possibly get an affidavit from her indicating, that it was used in that manner, although we supplied the leases, which I think proves that it was rented in the same manner. He took subject to the existing leases at the time, which were 6 on one side, 4 on the other, and he also took subject to the following year's leases. And we supplied the board with copies of those, which indicated they were being rented in the future, 6 on one side, 4 on the other. So we'd like the opportunity to maybe even go back in the chain of title, maybe to the prior owner, and we may have to go back, even further to locate and get evidence for the board to show that possibly this was operated in this manner way back before the law went into effect.
So you're willing to concede that you violated the statute, but that it's pre-existing and therefore you should be grandfathered in?
Well, I believe my client, I'm not even really sure whether he was aware of the existing law. And to my understanding, I'm not really sure when this law went into effect. But yes, when he received notification, he did realize that he was in violation, and that was his first instinct and discussion with the zoning administrator, was that he was going to bring the property into conformity.
When we bought the property, there was a search done, municipal search, and there were no violations.
That's how he purchased the property. So what he's trying to indicate.
I haven't changed anything.
Right, and we supplied a copy of the contract of sale, or relevant portions of the contract of sale, which indicated that there were going to be no violations on record, and he wouldn't have purchased the property if there were any violations. We also indicated in our application that the building and the fire department, I believe, came and did inspections, and they were fully aware that the property was being rented in this manner.
Okay, last time also, I think I asked you to supply any driver's licenses or other records of the government-issued ID of any of the tenants. Were you able to do that?
He was not, Your Honor. He was not
Okay.
able to.
Four of the girls that are there are from New York. 2 are from New Jersey. And the other side, all 4 are from New York. So only 2 out of the 10 total people that live on the property are from outside of New York.
Okay.
Okay, but that wasn't what I was looking for. I just wanted to see what they use as their address. But you're not able to provide anything like that?
No, not at this time. But my reading of the code is they don't have to meet all of those, correct? I mean, they don't have to have their, I just wanted to clarify. But we weren't able.
That would be a good one to meet, though.
I understand, but unfortunately, we weren't able to.
I mean, people usually when people rent, it's not uncommon for people to come from an area further away from the
I
town.
don't
of
think we're
Poughkeepsie.
concerned about where they come from.
Right. Does this town require people to not be from Poughkeepsie?
Absolutely not, but you're here asking for an interpretation of the definition of family, and there are some criterion to meet that definition, and you haven't been able to provide that.
So can a family become a family once they move into the town of Poughkeepsie?
Absolutely can.
Okay.
I-
Yeah, Betty, go ahead.
Last month, when we were done with the public hearing, I had the impression, or I was under the impression, that you were willing to conform. And now I'm getting the idea that is not what your intention is at all.
Well, I think it's a little complicated, because he is willing, ideally, he'd like to be grandfathered in, because it's been operated in this manner. Secondly, for our purposes, for these particular tenants, we like an interpretation that they do qualify as a family unit pursuant to the affidavits that we supplied. I mean, they do meet many of those criteria. It's a long-term lease. And then, I guess ultimately, he may have no choice but to bring it into conformity. At least, in the meantime, if we can go back to the zoning administrator and possibly do the minor alterations.
We're just trying to show that, we've only had 10 people there, which we're allowed to have 10 people. It's just the breakup of 6 and 4 or 5 and 5. So we could have 5 and 5.
For purposes of safety.
We could make that work.
Right. By making those minor alterations, it's not going to change the fact that 10 people will still be residing in that property. So by making those minor alterations, we can have 5 on one side and 5 on the other. So technically, we could still have the same 10 people residing there. It's not going to change that. He's never gone over the 10. He's never had, 6 on one side and 6 on the other or anything like that.
So I've been operating the property in good faith, knowing that 10 people can be there.
Oh, so you knew about the 5 and 5?
Yes.
Yeah, okay. So, and
I
one,
inherited this, and it was being operated in this way before.
the
I
people
purchased the
the
property.
students that are there now, how long before their lease runs out?
I believe at the end of.
This lease runs to the end of June.
This June?
Right.
And
But
it's
for all
not,
intents and purposes, at least one of them is going to wind up leaving. They're graduating in May. So graduation is roughly, I think, the third week in May.
Yeah.
So most likely by the end of May, there may not be anybody living there.
so then you could actually conform
Yes,
after
well,
May?
I mean, I can't force my way in and just go in and do construction in the middle of a
Right.
lease.
Right.
And, I already have a signed lease for the next year. But I can ask the next tenant if they will allow me to go in there and make these alterations.
Are they there during the summer?
Sometimes,
Sometimes.
yes. I mean, I don't know what their plans are, the next tenant.
Okay. I'm done.
But you have 10 lined up for next year.
No. Right now, because of this issue, I rented the place next year to 5 on this side and 4 on the other. But I can, there's already stairs going up on the other side. So all we have to do is open it up and put a wall up, and you can have 5 and
And you're
5.
home free?
So it's the same amount of people. It doesn't affect anybody. It doesn't change any noise. It doesn't change with the neighbors. It's just a technicality, if you will.
And the reason he does have the apartments rented in that manner is because of this issue. So, like I indicated earlier, his intent was to bring the property into conformance.
I could have physically rented the place to more than 6 people, but I've always restrained myself to the 10.
Tony?
No questions.
Okay. I have one specific question, and that's, the house was built as a duplex.
A legal two-family house.
Two-family. And I noticed that the number is 92, Is there a separate number for the other unit?
On the tax bill, I believe it's known as, the address they give it is 92 Fairview, because I think they can only give a property one address. But there's 90 is the one side for mailing purposes and for 911.
Okay.
90 is one side, 92 is the side we're talking about.
When I was there, it looked like there were two entryways,
They're totally separate.
but they're both 92.
No, there's there's a number 90 on the front of the left side.
Oh, okay,
and a
that was
92 on the
my
right side.
question. That was my question. So there's a one-family residence called 90, there's another one-family residence called 92.
Yes, but the property is a two-family.
Yeah.
Right.
No, and they're in one connected building, right? And
Yes,
that's- okay.
but the utilities are separated and the entrances are separate.
Okay. All right.
Is that April?
I'm trying to sort through, there are a couple of different things that you've suggested. One is that with some small construction, you could make this into something that would conform. Fine. The others, you've suggested that this is something that might be grandfathered. That's another argument. What concerns me is that what is in front of us is neither of those. But what it is an interpretation of what constitutes a family. And I'll be quite honest with you, when I look through the criteria, I find it very difficult to think of 6 college students as constituting a family as defined within our code. And the portion of it that to me is most difficult is, and I'll just read it, it's criteria number 2, whether the household has stability akin to a permanent family structure. And then it goes on to list a number of criteria, including the presence of minor dependent children, the presence of an individual acting as a head of household, what Mr. Leahy raised, that people use this as a permanent address when they're applying for things like driver's licenses or taking out loans, tax returns, and so on. It lists a number of things. I understand student housing is important.
I would suspect that they do whatever they need to do within the time frame of the lease that they're there,
Yeah, but I find it very difficult to think of, 5 or 6 college students as having the kind of stability and coherence that constitutes a family, as it's defined here. So I'm actually sympathetic and to the other arguments you made about, well, we could modify it so that it would conform to the law. Fine. Perhaps there is a case to be made for grandfathering this in. Fine. But that's not what we're going to have to decide. Those are arguments that you could take up, but
what is it about just one more person that changes?
Because that's what the law says.
Because that's what the code is. It says that.
But it's not that people can't be defined as a family.
A group of unrelated persons numbering more than 5 shall be considered a family upon a determination by the Zoning Board of Appeals that the group is the functional equivalent of a family pursuant to the standards enumerated below. The code makes it very clear how we have to make that determination, and I'm just telling you, when I look at those criteria, I don't see a compelling argument for deciding that, this group of students, as admirable as they may be, and I wish them well after graduation, but they just don't constitute a family by the standards that we have to use.
I believe we meet most of them.
And that was going to be my argument, too. I mean, the
Almost all
code
of
says
them.
that the following criteria shall be considered.
They don't
It
have
doesn't
children.
indicate- But it doesn't indicate that all of them must be met. So according to our documentation and our testimony, the length, some of the things to consider, the length of stay together among the occupants in the current dwelling unit. So we've also, shown through their lease that it's been at least a year. I believe my client may have testified the last time that, or maybe their affidavits also indicate that if they weren't graduating, they would have all remained together. They chose to live together. D, we've provided proof of sharing expenses for food, rent, or ownership costs, transportation, and other household expenses, utilities. E, common ownership of furniture and appliances and the common use of vehicles. I'm not sure if that was in their affidavit. F, whether the household is a temporary living arrangement, which we indicated is not. I mean, it's a yearly lease. Like my client indicated, some, marriages don't last a year and they live together.
There's no town definition of a lengthy lease that I'm aware of.
All right, I mean, I think of a year as temporary, but I've lived lots of places, for a year at a time, and away I went. Then you have other criteria, whether the composition of the household changes from year to year or within the year. Clearly, this is what happens. Okay, I don't think the issue is, do you meet the majority of the items? But to me, taken as a whole, and reading, and I've read through all of the affidavits, that taken as a whole, this just does not meet particularly the stability criteria of a family. These may be people are very good friends, they get along, whatever. But this does not meet what I read in the code as the intent of and the concept of a stable family. So I just wanted to make that clear. Larry, questions?
No questions.
Paul?
No.
Carmen?
No questions.
Phyllis?
No questions.
Okay. There are questions from any other board members? Anyone in the audience that wishes to address the application at 92 Fairview Avenue? Seeing none, is there a motion to close the public hearing?
So moved.
Second.
All in favor?
Aye.
Aye. Opposed? Recusals? Okay, thank you. Okay, we have received, the board has received a letter from the attorney for the applicant of numbers 7, 8, and 9, indicating that they wish to withdraw the application. We are withdrawing the applications. Violations have been corrected through purchase of another property. And we will
6 and 7 and 8.
deal with Sarah Davis to resolve the outstanding notices. So
It's 7, 8, 9. Okay.
items 7, 8, and 9 have all been withdrawn. I also understand that items 10 and 11, they've asked for an adjournment until, okay. So is there a motion to adjourn items number 10 and 11, 11th?
So moved.
Second.
All in favor?
Aye.
Aye. Opposed? Recusals? Okay.
Right.
All right,
10 and 11 were adjourned.
finally, we have finished the old business, and now we'll come to the new applicants, and for all of you, thank you for your patience.
Yes.
Item 12, Michael and Linda Cronk, 190 Rochdale Road. Good evening. So if you would both just state your names, please.
Michael Cronk. Linda Cronk.
Mr. and Mrs. Cronk, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please be advised that you are under oath, and any false statements made by you are subject to perjury pursuant to the laws of the state of New York.
Okay, just briefly, what are you looking to do?
We are looking to replace our carport that fell down because of the snow last year with a garage. That's pretty much it. And
The reason for the variance, the back wall on the existing carport was 6 feet off the property line. So just in keeping with fences that are already erected, things that are already in place, we wanted to just start that, use that as our starting base for the garage. We don't have another garage on the property. We also don't have a basement. We have very limited storage area at this point.
you were there, all of our stuff is outside.
Okay. Christine, questions?
No questions.
Okay, Betty?
So the carport is 6 feet from the property line?
The back wall of it, yes.
The back wall is still standing.
Yes.
Yeah,
And I left it up for
we
that
could see
reason.
that.
Yeah.
We could see that. And so to bring it forward would mess up what?
Go ahead.
There's a wide gate in the fence along the side of that.
In
where we wanna
the
put that.
back portion, in the back of your
Yes.
house? That goes to, is it East Bank it goes to back there? What's the
That's
road behind your
us.
house?
That's bank.
Bank Road,
Bank Road,
yes.
okay.
Yes.
Well, alongside the fence that's there
Mm-hmm.
next to the garage, not behind the garage.
Okay.
There's a big gate there. The way that I have it planned out, the front of the garage is gonna line up with that gate, so I could still get anything into that yard. You know, the
Okay.
garage isn't gonna cover
Yeah, 'cause
any of
your-
that gate.
Your backyard is in effect divided into two halves by a fence.
Yeah.
Right. Yes.
With the gate in it.
We have dogs, so they stay in,
Okay.
okay?
Okay.
Well, they were barking at you.
Now that you remind me, yes.
Yes. But that's their yard, but I can still bring, if I wanna put a car in there, you know, I have room with that gate. I don't want the garage to cover any part of that gate.
Okay.
That's
Any
where
other-
my measurements came into
And,
play.
and you're not gonna use the garage to put vehicles in, right? Because it seems like there isn't gonna be any driveway from your driveway to the garage. Are you
We
gonna?
can drive through there, you know, but mainly it's storage.
He thinks I'm gonna put my car in the winter. I'll try.
Because then she has to walk through the snow.
Right.
Well, you couldn't get there now anyway, right?
Well, yeah, there's a partial driveway down to that, so it would just, it would mean just adding, either a little pea stone or something back there to actually create more of a driveway. There was, years ago, there was a whole circle in that area that was like a driveway circle, but over the years, we just haven't used it and grass has grown up through it.
We bought the house from her family. So it's, how it was is how it was.
Yeah, that's, the house itself was actually a garage for the house next door. And in 1945, my grandparents turned it into a house. So now we're adding a garage to a garage.
All right.
Okay.
I'm not sure what provision of the code.
Yeah, no, I'm not even gonna
The
go
main
there.
thing is, the carport was already 6 feet off, because I measured, there's 2 stakes in the back. And basically that tree line going across the back, that's the line. The carport was 6 feet off the line. I'm not looking to change anything. So that's where we're at.
Okay.
Any other questions?
No.
Okay. Tony?
Larger is the garage than the carport.
It's basically doubling the size of it, give or take. It's about the same length, the 20 to 24, and then whatever a carport is wide, So 8, 10 feet, so
That one was actually 12, because when I did the measurements for the
24,
insurance
so-
company.
Well, you
yeah.
have
Basically-
24 by
basically-
24 on the,
Right, and we're,
right,
so we're doubling it.
yep. We have a lot of stuff to put inside.
we noticed.
Yeah.
Okay, I get, they've covered all the questions I had. Larry?
No questions.
Paul?
The gate that you're talking about, that's on the fence that's behind the house? Or behind where one of the RVs was?
There's a horseshoe fence that goes around for the dog yard.
Right, behind the house.
Right,
It's,
yes. And the
it's
gate,
next to that. The garage is not directly behind the house inside that
Right.
dog fence.
Right, but the fence that you're talking about is on, the gate that you're talking about is on the fence that goes behind the house, not on the property line to the.
Right,
Yes.
right, yes.
So explain to me what you're gonna get from the back, from behind the house into the garage?
Anything I want to.
I think our main concern is leaving the availability of that gate open because our septic tank is in that yard.
Right.
So if there ever arises the situation where we need the tank pumped and things like that, we want to make sure we have easy access into that yard.
Can you tell me how far behind the house the gate is? Or how far in front of the proposed garage the gate is?
Basically, the front wall of the garage
Right,
would line up with the rear post of the gate.
okay.
Okay, so basically the gate, if you just drove straight across the front of the garage, you could drive right into that yard.
Okay.
So the gate basically starts 24 feet from the property line where the fence is, in essence, because the fence is just about on the property line.
Okay.
Yeah.
Okay. All right, that's all I have.
Carmen?
Yes, when we were out there, there were 3 trailers out there, right?
Yes.
Yeah, and are they all registered?
No, they're not.
They're not.
One is mine, 2 are friends campers that need work done on them.
That need work done.
Yes.
And so are they kind of going to be there semi-permanently?
No, they'll be gone.
They'll be gone.
One by one, they're gonna leave.
Sooner rather than later.
She says the same thing.
Right.
Yeah.
Yeah, because it amounts to a lot of clutter in the front yard,
Oh,
that's
I
for
know.
sure.
Yes, absolutely. I don't like looking like Sanford and Son.
I think there was 4 there when they were there. wasn't
No,
there? No?
No.
Okay. That's right, because I moved stuff around.
right.
Well, if this is granted, I certainly hope you get to put your car in the garage this
Thank you.
winter.
I would
Thank
love
you.
that.
No further questions.
Okay. Phyllis?
And siding on the garage is gonna match the house? How are you gonna manage?
It will be white. I'm looking to put up a steel building. It's a prefab steel building.
And will you have electricity out that way?
Maybe down the road, not right away. It's just a place to put stuff right now.
And when were you planning on having this put in?
As soon as we can.
As soon as possible.
Yeah.
Okay, and so you.
It's getting warm out.
To have it done.
Well, I'm gonna build it.
You're, okay.
Yeah, whatever portions of it we need to contract, we were waiting until all of this was approved to make sure we had this before we line
Forward.
anything else up or put any more money out.
Right.
I have no further questions.
Okay. There are no further questions from the board. Is there anyone in the audience that wishes to address the application at 190 Rochdale Road? All right, seeing none, is there a motion to close the public hearing?
So moved.
Second?
Second.
Okay, all in favor?
Aye.
Aye. Opposed? Okay, thank you very much.
Thank you.
All right, number 13, John and Laura Augard, 2 Marwood Drive. Okay. Okay, good evening. If you just state your name for the record.
Yes. John Agard.
Mr. Agard, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please be advised that you are under oath, and any false statements made by you are subject to perjury pursuant to the laws of the state of New York.
Okay, so if you just briefly describe your application.
Yes. On the application, we are applying for a shed, an 8x12 shed, storage shed. And we have as my wife mapped out, she's the artist, on the map, a vinyl fence. We wish to put the 8x12 shed behind the vinyl fence, 1 foot, as stated, from the property line. We, in our opinion, can't really think of a better spot to put it. There is the backyard. However, we have such a small backyard. We have, I think, 0.24 acres. I think it's on the application, but we have such a small backyard. We have 2 children, 2 girls, 11 and 8. And, we want them to have the space to play. And that's kind of the best place we can think of is putting the shed. It's kind of on the side of the house.
Okay. Christine, any questions?
No questions.
Betty?
I have no questions.
Tony?
No questions.
Do you know how tall is the shed?
It's a good question. It's 8x12.
I think
it's a Patriot A-frame.
Looks.
I'm sorry, I should.
Like it's.
I've been to Gray's Woodworks.
Yeah, you've included some specs for it.
It looks like it's more than 8 feet.
8 feet, something like that. Yeah. Okay. And the fence, I believe, is what, about 6 feet?
It's 6 feet high.
Yeah. So there'd be just a little bit of it that would be
a little
even
bit
visible from the road.
Yeah, a little bit. And
okay. Larry?
No questions.
Paul?
No.
Carmen?
No questions.
Phyllis?
No questions.
Okay. Does anyone in the audience wish to address 2 Marwood Drive? Okay, seeing none. Is there a motion to close the public hearing?
So moved.
Second.
All in favor?
Aye.
Opposed? Recusals? Thank you very much.
Thank you.
Okay. Item 14, Stewart Shop, 85 Creek Road.
Jeremy Lawless.
Mr. Lawless, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be advised that you are under oath and any false statements made by you are subject to perjury pursuant to the laws of the state of New York.
Okay, so what are you seeking to do?
We are here today. I'm representing Stewart Shops for our shop on Creek Road, proposing to add signage to our shop. In the case of our freestanding sign, we'd like to install LED gas pricing, which I guess under the code here may fall under the electronic message display.
Mm-hmm.
So we'd like to look at that in the sense that our signage really isn't going to be changing in an electronic message format, on a continuous basis other than a price change here and there.
Okay. And it goes on an existing sign?
Correct.
It looks like you're changing the design a little bit.
That is correct, yeah. We are kind of slowly changing our signage throughout the company as far as kind of the look of it. And in this case, we'd kind of do it in conjunction with the hope of changing our mansard sign as well. And while we're doing the mansard sign, also change the freestanding sign to do our new sign. Our new logo in this case here, and while we're at it, oftentimes we try to look at it of efficiency for the shop, efficiency for using LED whenever we possibly can.
Okay. Christine?
No questions.
Betty?
I have no questions.
Tony?
No questions.
Okay. The big concern with these signs is, when they're flashing or changing or whatever,
Right.
and it occurred to me, I wonder if we could add a condition that the only time you can change the sign is to a lower number.
I'll have to look into that. There's higher powers going on here.
Yeah, okay. Larry?
No questions.
Paul?
No, I don't have any questions.
Okay. Carmen?
What are the hours at the Stewart Shops?
I don't know this specific one. I apologize on that, but typically they close. They're usually tend to be a 5 5 in the morning sort of a shop to 11 or 12, somewhere in that area. Each one kind of varies, to be honest with you.
I was just thinking about the lights.
Oh, sure, yeah. Well, as far as the lighting goes, I mean, you're still
And
going to
I
have
believe
the...
It's 11 o'clock is the time, isn't it? Or is it 10?
I think it depends whether or not the business is open. I think if the business is not open, it has to close, the lights have to go off
Right,
at
that's why
11.
I asked him about what time it closed, because
Yeah. I believe that's what's in the code.
the powers that be do not like the lights to be on after 11,
Oh, understood, understood.
if it's not open. And no further questions.
Okay.
Phyllis?
So you can only use the LED lights to list the gas price. It can never be used to,
That's correct, yeah. It's gas pricing only.
okay, thank you.
Mhm.
I have no further questions.
Okay. Are there any other questions from the board? If not, is there anyone that wishes to address the application at 85 Creek Road?
Let's put in just time. Put in their time.
I'll try.
My name is Louis Sala. I live at 82 Creek Road, Poughkeepsie.
Mr. Sala, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be advised that you are under oath, and any false statements made by you are subject to perjury pursuant to the laws of the state of New York.
Yes, sir.
I've lived at 82 Creek Road probably over 70 years, and I wasn't too happy when Stewart's built their place across the street. But I have to admit, they've been a big asset to the town. They're very friendly to the neighborhood, and I wish you would grant anything they want. I don't only complain, I do help when it's...
Okay, thank you, appreciate it.
So do I.
Okay. All right, if there are no other comments on 85 Creek Road, is there a motion to close the public hearing?
So moved. Second.
All in favor?
Aye.
Aye. Opposed, recusals? All right, item number 15, Maria Balbo, 788 Main Street.
Hello.
Good evening, and thank you for your patience.
My pleasure. Actually went quickly. I'm used to planning board meetings. So 15 applicants. I thought I'd be here till 11:30.
Okay, so if you need to state your name and be sworn in, please.
Jordan Valdina.
Mr. Valvina, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, and it's Valdina with a D in the middle. D like David.
sorry.
Valdina. No problem.
Please be advised that you are under oath, and any false statements made by you are subject to perjury pursuant to the laws of the state of New York.
Okay, go ahead.
Okay, so this building on the corner of Raymond Avenue and Main Street had this, nearly exactly this footprint of a single story addition, you could call it, on the front of the existing masonry three-story building. And that was demolished following the observation by the town of some structural issues up above and masonry and with the parapet, et cetera. So it was demolished for the safety basis, and my client, Maria Balbo, first decided to not rebuild it, thinking that was a cheaper way out. It turns out it's not particularly while it's the loss of a valuable asset. So we would like to rebuild in place what has been there for many years but has recently been demolished. And to do so, we would come basically right up to the property line on the Raymond Avenue side, and right to the drive. My best way of describing it is it's exactly where it was. It would be a retail use not specified yet. It was a Verizon store, and Verizon moved. That's the short story.
Okay. Christine?
No, I don't have any questions.
Betty?
When you say up to the property line, how far does that go? Right up to the sidewalk, or?
The property line does go right up to the sidewalk. Yep.
Because it seems to me what was there before was very, very close, almost to the road. When you went around the corner, it felt like you had to go way out of your way to walk past there. And across the street looks very nice.
Mm-hmm. That's interesting dynamics going around a corner. It is a risky thing. If you have a stoop, for example, a step, sometimes people will trip on it. But historically, you've often seen that, and lately, you've often seen them go away for the reason that you're talking about, on foot, going around a corner. Some things that can help that are it's more visual clarity, I find, rather than it's actually in the way. So our body gets expectations of where we think we should be able to go, and we go for it. And so if our visual cues are not good, we stub our toes or trip and the like. So while it is close, it's actually not literally in the way of the sidewalk width. So I think part of the new design and lighting will help create a very clear visual clue to not try to cut the corner.
Because almost everything on Raymond Avenue, if you stood right where the sidewalks are there, everything going down Raymond Avenue sits back. So this
Right.
would be the only thing that protrudes way out.
Right, yeah. It's important to keep in mind that it's exactly where this was in the past, but your point is taken, yeah.
Okay.
Does
So
stick out.
the intent here actually is to build something that you could, or your client could get a return from.
Yes, rentable square footage, yeah.
Now, does the whole building, is that part of the parcel?
Yes.
It is?
Yep.
Okay. All right, that's all I have for now.
Okay, Tony?
No questions.
Okay. Yeah, I struggled a little bit and finally had to go to the county records, and there's actually a fairly large parcel on which there are several buildings, and this is part of it. And so I was trying to see where some of the numbers that had to do with lot coverage came from. The impervious surface, I understand, but it says that the lot coverage is going to be 97%. It looks from the drawings as if there are fairly large parking areas. And were those counted in terms of lot coverage? Certainly they're impervious surface. That I get.
Yes. I'm sorry, I'm just trying to find where. Oh, is this in the written material we submitted?
No, well.
I'm about to blame my draftsman, but don't worry, I won't.
No.
There might have been a confusion in interpretation as it went out the door from my office, however that
It's
took
just
place.
that,
That's what that sounds like.
In the, essentially, it's the site plan.
Okay.
Drawing showing the proposed addition.
Yep.
Which is hatched, and then there are three, looks like separate buildings. They're side by side. Then there's a fourth one, slightly detached. But around it, it looks to be
right.
blacktop driveway.
It is.
So I'm not.
Where did the 97%, where was that written? That was my question.
That is on the application.
Oh, okay.
Proposed construction will be so many feet from the right-of-way. Also, the applicant is seeking a variance for a lot coverage of 97%, where 60% is the standard, and a variance for impervious coverage of 100%, where a maximum of 95% is permitted. And this is in the Arlington district.
97% is in error. I don't know how it came to be, but that is in error for the reasons you stated.
Okay. Okay, all right. So, I'm not sure this is, to me at least, let me not speak for the board, but at least for me, this is not a big issue. I mean, the buildings are there.
Right.
It's the Arlington Town Center, and in that whole district, people are actually encouraged to fill in and so on. So but I just didn't know where the number came from.
I'm not sure offhand.
Okay.
I apologize.
Okay.
It sounds like a mistake.
Okay. So you may well need a variance for more than 60%, but certainly less than 97.
Yeah.
Okay. Larry?
No questions.
Paul?
No.
Carmen?
Yes, I have a question about the materials that you're using for the bump out or the new building. It's not going to be the brick?
Just to hear about the materials? Yes. There would be a masonry-based, literally low, like below the aluminum frame windows, approximately, comes up to roughly 2 feet, and lower at the storefront glass with typically like a stone cap. So that masonry sort of ties it thematically into the building. It decidedly looks different than the building and yet related. Then above that would be like a stucco or an ephes type of system, a masonry type product, sort of like a beige type color that's, if you see around that building, there's already that more recent material at the first floor level, and then a metal roof.
Okay.
I think it would look sharp.
I hope so.
Yeah.
It's an interesting looking building anyway.
Yep.
You know, it's been there a long time. No further questions.
Okay. Phyllis?
I have no questions.
Okay. Any other questions from the board? Okay. Anyone in the audience wish to address 788 Main Street? Okay, hearing none. Is there a motion to close the public hearing?
So moved.
All in favor?
Aye.
Opposed? Recusals? Okay, thank you very much.
Thank you.
All right. Okay, brings us to the end of the agenda. We will now go into the deliberation phase. Does anyone wish to take a brief recess?
No.
Keep going?
Keep going.
Keep going, okay. All right. Item number 1, Leanne Lee, 81 Buckingham Avenue. This is, okay, actually, Sarah Davis has sent a memo clarifying this so that what in fact the variance should state, it's a variance to allow a driveway with a width greater than 15 feet. So the relevant section is Article 210-92-Q-1, which states, for uses requiring 4 or fewer parking spaces, said driveway shall not be less than 8 feet nor more than 15 feet in width. So the variance is to allow a driveway with a width greater than 15 feet. There's a type 2 action, so there's no environmental. The county is a local concern. And in your packet, you'll find a staff report that recommends that this application be denied. And then you also have the amended version in which the utility pole would be surrounded by a 4-foot buffer. Okay, discussion, comments?
How do you go? At first, I couldn't understand what putting a 4-foot buffer around the telephone pole was going to help. Mark helped us out with that. Now, you're saying that because when I read the code, I wrote down 4 or fewer parking places, the driveway should not be less than 8 or more than 15.
Right.
So because they need, well, she said they need 3. So,
Or, yeah.
So it should be
They're talking about 3 or 4, yeah.
so that doesn't help.
No, Okay, no, it says for uses requiring 4 or fewer.
Right.
Okay.
It should not be wider than 15.
Right.
Right, so the variance is because it's wider than 15 feet.
Yeah. The back of the driveway, according to the drawings, is going to be 25 feet. So that's what they need a variance for. The 25 rather than 15. And so now and then the issue, as Mark Pfeiffer described, was that when this was initially submitted and when the initial staff report was written, there had been no permit issued for this driveway. And when they did approach Mark, he said, no, you just can't have a utility pole in the middle of a driveway. And then they came up with a way of addressing that. So I think that's where we are now.
So for question number 3, whether the requested area variance is substantial, it's 100% variance, just about.
Well, it's 10 feet more than the 15. So it's it's an increase of 2/3.
All right.
Yeah. So, yeah, it is. It's a substantial change. Yeah. Any other comments?
Yeah, due to the unique nature of what's happened in the past, the fact that the pole is there, that's quite clearly an impediment to utilizing the driveway. The applicant talked about that the garage was difficult to use based upon the buildup of macadam in the driveway. I think that Mr. Pfeiffer's suggestions for protection of the utility pole make a lot of sense, and I think it would allow to be granted the variance.
Okay. Yeah,
I agree with what Paul was saying.
Really?
Yes, I do. I want that to be on the record. But anyway, I think Mark was doing his best to accommodate him and allow them to use the driveway.
For our council?
And the liability has also been addressed as far as the town is concerned.
Yeah, yeah.
Do we need a hold harmless clause or something from the applicant, or is that just not really necessary?
As a council, I never think it's a bad idea to have something like that in the file, and I'd be happy to draft something. The applicant seemed willing to sign it, so I think that's not a bad idea. It's, obviously it's in the record, but I still think having a signed document is helpful.
Okay. So we could add as a condition that the applicant,
Execute a hold harmless.
okay.
Okay.
Does that,
That's fine. Yeah.
that work for everybody?
So in case of a suit, the town will be rendered not.
Right, right. Somebody driving along the road, get a little bit over to the edge and clip something, and so we have it now in writing that, it's not the town's liability.
We allowed
Interesting.
that to occur.
With the condition that they assume responsibility.
They're not gonna be able to may not be able to assume the responsibility that's warranted in any particular case.
The hold harmless clause would not prevent the town from being named in any suit. What it could do is, in essence, indemnify the town so that if the town were found to in some way be negligent, the monetary responsibility would fall on the property owner.
Okay. That,
Then we make sure it's really not dangerous, because it could be that some poor soul is gonna really be out of luck if they can't recoup money from the town. I mean, is it really that unsafe that, that could happen?
well, yeah,
I mean, he's renting the house out for, we know, that's, you know, the people can get nothing from that. So if it's really dangerous, we're committing some poor person who runs into that, you know, to not be able to get anything.
Okay.
I mean, I don't know how unsafe it is, I mean, unsafe it is.
Right, and I don't, you know, you're asking the wrong person here.
I'm going to ask a question, probably a naive question. Is that telephone pole on town property, or is that the owner's property?
Well, he built the driveway there, it's gotta be his property.
I would think.
I can't tell from the record whose property it is. It's possible there's an existing easement there for the utility pole. The board does have the ability to hold off making its decision tonight, and we can see if we can determine the ownership of the pole or the property, and see, you know, where the boundary line goes. What currently exists, what the board's being asked to approve is a wider driveway. The only issue that might potentially increase the liability is that the town is asking for a buffer to be put around the driveway, but it's also asking for it to be flush at the road level. So I don't know that that would actually increase any danger, but, you know, but to answer the question, the specific question is, I don't know, and I can't tell from this record who owns the pole and the ground under it.
Yeah, I would just note that there are no curbs and gutters in that neighborhood. So in effect, the pole has always been whatever distance it is from the center of the road. So this actually doesn't change that. But it does put something around it. Which, you know, I don't think it makes it worse. I mean, does it make it foolproof? Probably not. I mean, I'm sure you're thinking of all kinds of scenarios.
Oh, no,
you know. Okay. All right.
I was comfortable till that came up.
I mean, I really do think adding the condition that the applicant provide a hold harmless document is probably about as far as we go. But so do we want to proceed on this, or?
I'm comfortable.
You are or you're not?
Yeah. It's nice.
Okay.
I agree with Paul.
Okay, let me put this in the form of a motion then. Okay, I move that the board approve the request for a variance set forth in item number 1. This decision is based on a review of the application, the testimony of the applicant, testimony offered in public hearing, the result of site visits by board members, and the board's findings. In approving this variance, the board adopts as findings the following. And this is a revision of the earlier staff report. Okay, application type, parking variance from Article 8, 21092Q1 of Chapter 210 of the Town Code to permit a driveway with a width of 25 feet where a width of 15 feet is permitted. I mentioned this is a type 2 action. 1, whether an undesirable change will be produced in the character of the neighborhood. The finding is the site of the current parking area at 81 Buckingham Avenue allows space for at least 2 or more vehicles. The proposed change may actually alleviate vehicles from parking on the street. And Mark Pfeiffer testified to that. Whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance. The proposed variance is necessary for the applicant to provide adequate parking on this site. Like many other properties on Buckingham Avenue in the neighborhood, some vehicles park adjacent to their properties, littering the street and neighborhood with vehicles. There is no area on the sides of the residence to allow for expansion to the side. Whether the requested area variance is substantial, the requested variance for this parking area is 10 feet, or is 25 feet where 15 is allowed, so the variance amounts to 67%, which is substantial. Whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood. Let's see. The applicant has applied for a permit for the proposed driveway, and the Highway Department has found that it is satisfactory. Whether the alleged difficulty was self-created, the applicant has paved this area without the proper permits. The applicant has since received those permits, and the fact
But,
that...
Mr. Chairman, I don't know if it was self-created. It was really the telephone pole, right, that created the need for...
Oh, okay, all right, yes. Well, and the previous, or the existence of the telephone pole created a difficulty in using the existing parking. Okay, all right. Okay, and the approval of this variance is subject to the following conditions. One, that a 4-foot buffer on each side of the utility pole be created. Two, that the buffer area be flush with the pavement on the street side and at least 4 inches above the pavement on the back side. Three, the buffered area must be landscaped with flowers or shrubs. And 4, the applicant must file a statement how do I want to put this? A statement that the town will be held harmless in case of any accident or liability.
Second.
Okay, I was going to say, so move. Okay, and Paul has seconded. Okay, any further discussion?
I have a question.
Yeah.
Say the first 2 sentences of that motion.
What the variance is?
Yeah.
Okay. A parking variance from Article 8, numbered Article 210-92Q1 of the Town Code to permit a driveway with a width of 25 feet where a driveway of no more than 15 feet is permitted.
Is that on some portion of the code I don't have again?
Let's see, I copied it out. Yeah. 210.
Q1.
92.
Parking or storage of motor vehicles in the front yard of any property located in a residential district is prohibited unless front yard is crossed by a duly constructed driveway extending through the front yard to a garage, carport, or properly surfaced parking area. For uses requiring 4 or fewer parking spaces, such said driveway shall not be less than 8 feet, no more than 15 feet in width.
Yeah, that's what I have. So we're not the variance is not for the additional on the driveway. The variance is for parking the cars in front, correct?
No, because he has a garage.
Well, that's what we advertise for.
Right, but that's...
Yeah, what we advertised was for that section, 92Q1.
There's no way.
Okay.
Yeah.
And Sarah sent us, when it first came up, there was a discussion of this, and then Sarah sent us a memo clarifying that the specific portion of that paragraph that we needed to focus on was the width. that because it was leading to a driveway, the other part of that paragraph was okay.
Okay,
That's not what she was being cited for.
okay.
So I think we're okay on that. But,
We okay?
yeah, the original staff report spoke to front yard, but that was not the issue. Okay? Any other discussion? Okay. On the motion to approve the variance, all in favor? Aye. Opposed? Recusals? Okay. On the variance with 4 conditions is approved. Okay, 2 has been adjourned. Item number 3, 7 Old Farms Road, a variance to allow a proposed home addition to be located 14 feet from the side lot line where 20 feet is required. This is a type 2 action. The county has made no comment. In your packet, there's a staff report recommending that the variance be approved. Okay, discussion, questions, comments?
There were numerous pictures as part of the packet, and pictures for the record, that shows many houses in the area have exactly the same form of addition. So it totally fits the character of the neighborhood.
Yeah, in fact, I was a little unsure of that, so yesterday I actually drove up and down the street, and quite a number of the houses have this kind of
L-shaped, it's like an L-shaped, yes.
Exactly, where either a garage or a room
Right.
comes out and then the rest is back. And then I took a hard look at the drawing, and I gotta hand it to the architect. I wondered why they did all this funny stuff with the roof line. And actually, it's kind of stepped back to avoid
A big block look.
big blocky wall that seems to pop out. So I agree with you. I think it fits fine. Any other discussion?
What Betty had said previously too, it doesn't alter the character of the neighborhood. And it looks fine.
Yeah. Okay. Christine, you want to make the motion on this one?
I move that the board approve the request for an area variance set forth in item number 3. This decision is based on a review of the application, the testimony of the applicant, testimony offered in the public hearing, the results of site visits by board members, and the staff report. In approving this variance, the board adopts as findings the determinations found in items 1 through 5 of the staff report.
Second.
Okay. Any further questions, discussion? If not, all in favor? Aye. Opposed? Recusals? Okay, the variance at 7 Old Farms Road
If seeker?
is approved. It's a type 2. All right, item number 4, U-Haul, 2175, 2185 South Road.
She's not.
Let's see, so we're down now to, this would be a variance to allow 2 wall signs of 40 square feet each, where only 1 wall sign is allowed. And so the other 2 are now withdrawn. And this is an unlisted action, but a environmental short form has been submitted. So I move that the Town of Poughkeepsie Zoning Board of Appeals declare itself lead agency for purposes of the environmental review of the application at 2175, 2185 South Road.
Second.
All in favor?
Aye.
Opposed? I further move that the Town ZBA, based on the information in the application and in the short form AF, finds that the action proposed at 2175, 2185 South Road will have no significant impact on the environment.
Second.
All in favor?
Aye.
Opposed? Recusals? Okay. So on the motion, comments?
I appreciate that they really reduced the amount of signage, but some of the concerns that everyone expressed about the need for that, it's a U-Haul. The storage place next to it doesn't have that much signage. I appreciate that they've reduced their application, apparently taking off what no one could figure out what the doors were. But I'm still not sure of the necessity,
Of what?
the extra signs.
The ones on the sides that say, for me, it has to do with the way the building is built. It would have big empty facades on either side of the front entrance, which, to me, are reasonable area to put signage in, and probably looks better with some signage as opposed to having nothing. It's a totally different shape building than the storage place next door.
Okay, I just don't think that's one of our criterion.
Well, I think sometimes that the fascia of the building or the front of the building gives us the discretion as to whether or not it needs something there. I think 24/7 or climate control is a big difference. If I was looking for a storage place, that's probably something I would look for. Although certainly it would not be an impulse thing.
Okay. But the climate controlled is on the main.
Right.
Okay. So.
The other one is
24/7 self-storage.
24/7 self-storage.
Which is likewise in the windows on the front.
True.
Yeah. Though very much smaller.
Yep, that's true.
It seems to me that looking at the building.
My real concern is that it's a commercial, it kind of overpowers the Bonefish, the restaurant part of it, the building next to it, so it seems to me that it takes away from the ambiance of Route 9. Such that it is.
Takes away from the ambient. I mean, you can't see it from Bonefish.
Is that a criteria?
No.
I mean, if you're in the restaurant.
Right, but as you're driving down, you see Bonefish, kind of a subdued sort of thing. The other storage place kind of subdued, and this one less so.
Yeah, I mean, the difference is, this is a long building. I mean, it stretches out along Route 9.
It was pretty good. Lazy Boy didn't. Lazy
it's,
Boy didn't have couches running down the side.
well, yeah, I mean.
It'd still be there.
Maybe.
Right.
Yeah.
But it's also using space that's already there, and I don't have any objections to U-Haul.
Yeah, I mean, I believe, well, I'm not so sure, I won't say. I was gonna think about what the previous signage had been, but I sort of remember as being extensive. But
Bonefish way up here.
okay.
Good point.
Okay, any other comments, questions? Okay, Betty, you want to make the motion on this one?
Sure. We did seeker already?
Yes.
And the county said it was okay, right? Okay, I move that the board approve the request for the area variance set forth in item number 4. This decision is based on a review of the application, the testimony submitted by the applicant, the testimony offered in the public hearing, the results of site visits by board members, and the staff report. And I ask that,
The staff report, unless there was a new one, wanted additional information.
Yes, let's see.
Or actually, was against it.
all right, so we'll have to go through it.
Okay.
Whether or not an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by the granting of the area variance. The site is a former furniture store. In reviewing the requested variance, staff notes that the application contains little or, if any, information as to the potential impact of the larger signs. Were there not signs on the left and right side of the center portion previously?
Yes, there was.
Yeah, so, it's already, signs like that were previously in the same area of the building, and it's consistent with other signage in the same area. Whether or not an undesirable change will be produced in the character of the neighborhood. It's a former furniture store. It's had it answers the same questions. It's had signage there previously in the same area of the building and without any impact that was negative. Whether or not the benefit sought by the applicant can be achieved by some other method. I guess that is true. It can be, they could have it on the doors as you walk in, but that does not preclude, or that's not a reason to not grant the variance. Whether the requested area variance is substantial. They brought it down from, it's not as big as it could have been. The applicant actually reduced the square footage of the signage. Whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions of the neighborhood. Granting of the variance would not create a precedent for other freestanding signs in the BH district that line Route 9. That is typical in Route 9 area for businesses to have enough signage to allow for patronage to find their location. Whether the alleged difficulty was self-created, I guess.
Betty, is there a freestanding sign that you're authorizing also?
No.
No, that already exists.
So that's what you just read?
It's there.
Right, so you just read granting variance.
Okay, actually, the freestanding wouldn't apply in any case.
That one's allowed, right? Isn't that one allowed?
Yeah, I mean, in that district, they're allowed a freestanding
Right.
sign by right and a wall sign of 100 square feet. Okay, and they are using both of those. So the variance now is for 2 additional wall signs.
The two 40-foot ones, 40
Right.
square foot ones.
Right.
Right.
And, you know, I think I would just say that particularly along Route 9, we have granted additional wall signs where they are appropriate. I mean, I'm thinking in particular, there was just one in the Poughkeepsie Plaza where they wanted one wall sign that faced Route 9, and they wanted another wall sign
That was Salsa, I think.
Yeah, exactly. So, you know, granting an additional wall sign would not set a precedent. This is something that we've done.
And I think you could actually assume that any application that is made is somewhat self-created, and that is not justification to not grant
Okay.
the variance.
Okay.
And like all signs, when the business is gone, the sign has to come down.
Right. Okay, is there a second?
Second.
Second.
Okay, any further discussion? All right, if not, on the application for a variance for U-Haul in item 4, all in favor?
Aye.
Opposed?
Nay.
Okay, and recusals, so approved, 6-1. Okay. Item number 5, Keith and Debbie Hofnagel, 131 Violet Avenue. An application for a use variance to allow the establishment of a restaurant in an R20 district. This is an unlisted action. There is an environmental form here somewhere. So
You're underneath here.
I move that the zoning board declare itself lead agency for purposes of evaluating the environmental impact of the application at 131 Violet Avenue.
Second.
All in favor?
Aye.
Opposed, recusals. I move that the zoning board finds, based on the information in the application and in the environmental assessment short form, that the action proposed at 131 Violet Avenue will have no significant impact on the environment.
Second.
All in favor?
Aye.
Opposed, recusals. Okay. So the motion is to grant a use variance to allow the establishment of restaurant in an R20 district. Okay. Discussion, comments?
There's been some comments about whether he's overcome the self-created issue problem. And assuming that that's everything he says that was done in good faith, I agree that he probably has overcome that. My concern is that the initial burden is on the applicant to show that there's no reasonable return from any of the permitted uses within the district. So some of the permitted uses are cemeteries, country clubs, dwellings, family daycare homes, golf courses, libraries, museums, parks, places of worship, playgrounds, public utility structures, schools, and special uses, including accessory apartments, agriculture, bed and breakfast, daycare centers, fraternal clubs, home occupations, kennels, and so on. And the applicant, based upon my understanding of the case law, has to show a dollars and cents showing that he can't get a reasonable return from any of those uses. And I don't believe that he's done that here. The only comment that he made is that he's looked at childcare and said he didn't want to do that. The fact that he purchased the property and has expended monies is, I feel sorry for the guy, but the town has prohibited this use in that zone, and it's a very difficult burden to overcome, and I don't believe he's overcome it.
I seem to remember, and I'm hoping our council can bail me out here in my failing memory, that the last time we had a use variance like this, Neil cited some case law that suggested that that the applicant didn't have to go through each and every possible use in detail, that it was enough to show that the, oh, no, this is where I'm having trouble. Do you remember that?
I do recall it, not enough to be able to quote it, but I didn't agree with it, based upon all the other case law that I'd seen.
Okay.
So my question is this then. Because we do what we do when we do our homework, I went through all the permitted uses.
Right.
like you just did, and I know that the onus is on the applicant, but when I went down through all the lists, and I even did the special use permits, the only thing that that building could possibly be used for would be the daycare, which,
Why do you say it couldn't be used for a museum?
well.
Or a library?
Museums and libraries are typically bigger facilities. I mean, that's not a very big building.
Okay.
So my idea of a library or a museum would be somewhat larger. And so I assumed even a bed and breakfast, it would be a bigger building and with better facilities. Obviously, you'd have to have bedrooms or whatever. So the only use that I found would be the childcare, which is right down the road and a very big one, like maybe not even a quarter of a mile away. So what is it up to the applicant to?
It is up to the applicant to make the required showing. I haven't, because I'm new to the board, I have not seen Neil's memo, so I can't speak to that. I know that in general, if it's something that would otherwise not be feasible for whatever reason, the applicant doesn't have to, a simple statement, one toward that would be sufficient. But in this case, the applicant has come forward only with the evidence concerning the daycare. He spoke a bit to the daycare, but one thing the board does have before it is the cost to change this use to other uses, at least to a residential use. We don't have evidence of that. And as I said with the other issues, if the board wants me to take a look at this during the next 30 days, and you do have 62 days to make your decision, I'd be happy to do that. But you don't have to specifically dollars and cents, I believe, each use, but you have to show why that use would not be feasible in some way.
See, when we went to a class last year, and they did tell us dollars and cents for each use. My question was, if I can look at the code and say, well, obviously, it's not big enough for a library or a museum, or, would not be feasible to put a public pool there, all of these things that are allowed in that zone, is it okay for the board to assume that that's why he's not using that, or do they actually?
I'll give you the pool.
And the cemetery?
Yeah.
I'll go with the cemetery.
As a practical matter, the board doesn't have to suspend common sense when it looks at these issues. So if, for example, something were permitted that is so obviously not feasible, it's an exercise in futility to have the applicant go through and come up with the dollars that it would cost to
That's the
convert
answer
that.
I'm looking for. Thank you.
Well, if you want to apply common sense, really, he wants it to be a restaurant, and it was a restaurant for many, many years.
Common sense is it should be. We just have to find the right avenue.
Yeah.
Okay. My sense on this is that the applicant has in fact addressed the key issues. One, that not allowing a restaurant use would be an economic hardship. I think he's submitted a good deal of information on that makes perfect sense. And I think the second key issues that he's addressed is that he has acted in good faith in terms of the long-term restaurant use, and that given indications, certainly there were no counter indications that use couldn't continue, and so proceeded in good faith. And to me, those were the two most difficult parts of the application. as for the need to look at all the alternative uses, you know, I'm convinced that the data that he's submitted on, say, switching from a restaurant use to a residential use would be very, very similar to other proposed uses. And in fact, other proposed uses would make the financial hardship even worse. Putting in a golf course, I think we can rule that one out too. But even a museum use, to convert that building into something that conforms to modern museums, just in terms of, you know, the lighting and the climate control and whatever that you find in modern museums, seems to me it's almost obvious it'd be worse than trying to convert it into a residence. So to me, that has been satisfied. And I think I'm prepared to, you know, go forward on this tonight. But if people want to wait and gather more, we can certainly do that. We have 62 days to make a decision. But I'm not sure to what point.
No, I'm with you.
Yeah. Right.
So, so let's go. Let me put this in the form of a motion, and we can take it from there. Okay. So I move that the board approve the use permit, the use variance in item number 5 at 131 Violet Avenue. To allow the establishment of a restaurant in a district where restaurants are not a permitted use. Okay, this is an unlisted action. There's an EAF, so let's take care of the environmental first. I move that the ZBA declare itself lead agency for the purpose of evaluating the...
We did that.
Did we did that?
Yes.
We did that. Good. Oh, we can go straight to the heart of the matter here. Okay. Okay. The standard of review.
Amended.
No use variance shall be granted by the board without a showing by the applicant that the zoning regulations and restrictions have caused unnecessary hardship. In order to prove such unnecessary hardship, the applicant shall demonstrate to the Zoning Board of Appeals for each and every permitted use under zoning regulations for the particular district where the property is located. During the testimony of the applicant and subsequent discussion with our counsel, the ZBA finds that for each of the permitted uses listed in the code, the applicant would undertake unnecessary financial hardships. Additional considerations. 1, that the applicant cannot realize a reasonable return provided that lack of return is substantial as demonstrated by competent financial evidence. The applicant has submitted extensive financial information showing the amount of money spent to purchase the property, to improve the facilities, and has further shown that any attempt to convert the existing property to a permitted use, particularly a residential use, would be unduly expensive and would not generate a reasonable rate of return. 2, that the alleged hardship relating to the property in question is unique and does not apply to a substantial portion of the district. The applicant owns a property that's been a restaurant for since at least the early 1950s and is unlike any other property in that neighborhood. 3, that the requested use variance, if granted, will not alter the essential character of the neighborhood. The property in question borders on a very busy roadway, a state highway. It's again, a use that has been there and has been part of the neighborhood for many, many years. And 4, that the alleged hardship has not been self-created. Based on testimony of the applicant and the clarification of the relevant law by our counsel, the board finds that the applicant acted in good faith in pursuing the proposed use for that property. Based on these findings, a review of the application, testimony of the applicant, testimony gathered during the public hearing, the results of site visits for board members, and the input from the staff and our council, the board approves the application, the use variance application in item number 5. So move.
Second.
Okay, any discussion, clarification of my attempt
Well
to
done there, Mr.
draft this on the fly? Okay, if there's no further discussion, all in favor?
Aye. Aye.
Opposed?
Nay.
Recusals? Okay, approved 6-1.
Would you call that common sense? What? I don't write that down.
Okay. All right, okay. All right. Item number 6, New England Realty Group, 92 Fairview Avenue. A request for an interpretation of whether or not the occupants of 92 Fairview Avenue are the functional equivalent of a family as defined in Section 9, or Section Article 210, Section 9 of the Town Code. This is a Type 2 action, so there's no environmental. The county has not commented. In your packet, you'll find a staff report that concludes that there is no evidence to support the claim that the occupants of 92 Fairview Avenue are the functional equivalent of a family. Okay, comments, discussion?
I have a hard time voting for a variance when, well, it's not actually a variance, it's an interpretation, but the applicant is willing to conform.
Yeah. Okay.
And aside from that, in my mind, they don't meet the criteria.
Right, I agree, this is just an interpretation.
Yes.
And I believe that the information that they provided is insufficient to meet the definition as defined in the code.
Okay.
And, you know, it's clear that it's 5 unrelated people, and he basically said to us, well, what's one more? And,
Well, it's all in perception.
exactly, yeah.
Well, yeah, I think I was pretty clear during
You were.
the hearing part about where I stand, and to me, it's important to sort out what in fact we're being asked to do. What it is to look at a particular place and say, okay, does this or does this not meet the criteria of the code? We don't write the criteria. That's somebody else. Whether or not this should be grandfathered, that again is another question that's not not what we're being asked to decide.
Excuse me, Jim, that can be a very slippery slope with the grandfathering in, I believe, in
Well,
this specific situation with a rental.
yeah, but that would, but,
Right, but it doesn't, it's not, we're not deciding it tonight.
yeah, yeah. I mean, it could be, I just don't know. But in any case, the issue is, does it meet the criteria that are set forth?
Do you want to
And-
go through the criteria?
Well, it's, I mean, it's in the staff report, but I can summarize this. Let me do that as part of the findings. So let's just make the motion here. I move that the Town of Poughkeepsie Zoning Board of Appeals finds that the the occupants of 92 Fairview Avenue do not constitute the functional equivalent of a family, as that term is defined in Chapter 210, Article 2, 210-9 of the Town Code. This interpretation is based on a review of the application, testimony of the applicant, testimony gathered during the public hearing, the results of site visits by board members, and the staff report. And in denying or in making this interpretation, the board uses as its findings the staff report, which is summarized as follows. Family, as used herein, shall mean any number of persons occupying a single dwelling unit related by blood, marriage, or legal adoption, living and cooking together as a single housekeeping unit. Okay, and any number of persons not exceeding 5 and living and cooking together as a single housekeeping unit is the functional equivalent of a family. It shall be presumptive evidence that more than 5 persons living in a single dwelling unit who are not related by blood, marriage, or legal adoption do not constitute the functional equivalent of a family. So just on the face of it, the fact that there are more than 5 means that it does not meet the code definition. Okay. In determining whether a group of more than 5 unrelated persons constitutes a family for the purpose of occupying a dwelling unit as provided herein, the Zoning Board of Appeals shall utilize the standards enumerated herein in making such determinations. Okay. In determining whether individuals living together are the functional equivalent of a family, the following criteria shall be considered. 1, whether the occupants share the entire dwelling unit or act as separate boarders. The evidence presented is that the occupants share the entire dwelling unit, although they have separate rooms. 2, whether the household has stability akin to a permanent family structure. The criteria used to determine this test include the following. A, length of stay together among the occupants in the current dwelling unit or other dwelling units. The evidence presented is that the occupants are all under 1-year leases. 2, or B, the presence of minor dependent children regularly residing in the household. The evidence is that there are none. C, the presence of an individual acting as head of household. The evidence is that there is no one. D, proof of sharing expenses for food, rent, or ownership costs, transportation, insurance, utilities, and other household expenses. The testimony suggests that at least some, perhaps all, of these expenses are shared. E, common ownership of furniture and appliances and common use of vehicles among members of the household. The evidence suggests that the appliances, I'll go with the residents. To what extent furniture and vehicles are owned in common is very unclear. F, whether the household is a temporary living arrangement or a framework for transient living. The evidence is that the occupants are all students, many of whom are going to graduate and move away quite soon. G, whether the composition of the household changes from year to year or within the year. The evidence suggests that the composition changes every year. H, whether each of the occupants uses the address of the dwelling for their vehicle registration, driver's license, passports, bank accounts, bills, loans, tax returns, and other licenses and permits. The evidence suggests that many of the occupants use other addresses as their permanent address. I, any other factor reasonably related to whether or not the group of persons is the functional equivalent of the family. No evidence has been suggested that there's any kind of link or bond or shared experience or activity that would make them the functional equivalent of a family. Any determination of this subsection is limited to the status of a particular group as a family. We're only looking at this particular address. In no case shall a dwelling be occupied more than 2 adults to a conventional bedroom. We simply have no evidence on that, one way or the other. And G, persons occupying group quarters such as a dormitory, fraternity, or sorority house, or a seminary shall not be considered a family. That issue does not apply. Those are the criteria and for each of them the findings of the board. Any amendments that anyone wants to make to that?
You pretty much covered it.
Corrections of what I've said? Okay. All right, in that case, I've made the motion, recited the findings. Is there a second?
Second.
Okay. Any further discussion? Okay. In that case, all in favor?
Aye.
Aye. Opposed? Recusals? Okay. So the board finds that in the particular case, the residents do not constitute a family. All right. 7, 8, and 9 were withdrawn. 10 and 11 were adjourned. This brings us to item number 12. Michael and Linda Cronk, 190 Rochdale Road, a variance to allow a proposed accessory structure, a garage, to be located 6 feet from the rear lot line where 10 feet is required. It's a type 2 action, so there's no environmental issue. And in your packet, you'll find a staff report recommending that the variance not be granted. Okay. There are a couple of corrections need to be made to the staff report. Under the application type, it's an area variance from Article 4, Section 210-48. It's Section 48 that deals with accessory structures. And to allow the construction of a one-story detached garage measuring 24 feet by 24 feet to be located 6 feet from the rear yard boundary where the required minimum rear yard setback is 10 feet. So instead of 30 feet, it should be 10 feet. Okay, discussion?
Well, I think that the staff report recommended denials because there was really no reason in the application as to why they wanted to put the garage where they want to put it, related to the gate and perhaps having to get a truck or something in there to access septic.
Yeah.
So I have to wonder if that isn't why they chose to deny it.
Any other comments?
The backyard, there's 24 feet from the side line in the backyard.
Yes.
So I think that they could place it there and still have access to the rear behind the house and not need a variance.
I'll move it over closer to the right.
Yeah.
Well, why didn't you ask them that?
I was trying to figure out what a gate was.
Well, the other reason, locating where it is, and this was nowhere in the application, is that it replaced an existing carport. And until we went out there and I looked at it, why it was located where it was seemed arbitrary. But when you look and realize that there had been a carport there for many years, and essentially we're taking that out and replacing it with a more substantial structure, made sense to me. Could they locate it someplace else? Well, let's see, 10 feet from the rear and from the side, would put it pretty much in the middle of their backyard.
Which kind of negates the use of as a carport if you put it in the middle of the backyard. You know, I mean, accessibility. If you're going to put a car in there.
Right, but the testimony was that this is primarily storage, so it seems to me instead of calling this a garage, we should call it a big shed.
Well, I think I would have
in terms of the code, it's no
if a
difference.
neighbor had come in and said, oh, well, I don't really want this encroaching on my property, but no one was here. And they've been notified, so.
Right. I read the staff report and I understand it completely, what was being said in the staff report. And yet I'm trying to find a reason not to grant the variance. And I can't really come up with one.
Yeah, I mean, it seems to me that the site visit and the testimony provided a rationale for locating it where they proposed to locate it. Yeah, it's a big shed, but it, and also I am personally influenced by this notion of, well, they have no basement, and
exactly
No attic and no basement.
I have a very big garage too, and it is chock-a-block with stuff. So I can understand why
they need some storage.
Yes. So
I'm clear on how any of that relates to whether they need a variance.
They need a variance because without one, they are essentially sacrificing most of that part of the backyard. And it could be an issue in blocking access to the other part of their backyard, which contains the septic system.
I don't think if they moved it over 15 feet or 20 feet or whatever it was to the side, the gate would still be open, accessible. The driveway, there were two real driveways, neither of which lead to the carport or the garage. So I'm just unclear why any of this leads to the conclusion that they need a variance.
Well,
I don't know why we should.
yeah, I mean.
Why didn't we ask that when we were speaking with them?
Well, we did. We talked about.
I don't think anybody brought up the fact that maybe they didn't need a variance and the garage could be moved over. As long as it was 10 feet off the rear setback, it could still be moved, as Paul's saying, being moved over to the, I don't know, is that the west property line? The west property line.
Well.
There was mention of septic, though.
That was behind the house.
East.
Yeah.
Okay,
Yeah.
okay.
But you know, we're.
You know what I'm saying?
Yeah, no, I exactly what you're saying, and I agree that it would be possible. Okay, except that it's not, the issue is not whether, he couldn't. The issue is the benefit to the applicant weighed against the impact on the neighborhood. And seems to me he's clearly shown, what the benefits would be. It goes on to something that was existing. It leaves open an area, a gate that he wants. It doesn't fill up the backyard. It allows use of that area. Seems to me those are benefits. And in terms of the negative impact, we have, as far as I know, no testimony. So, in terms of that balancing, I know what you're going to say. It's that the code clearly says that we should grant the minimum variance needed. I think in this case, he's the benefits that he's seeking would justify the larger variance. So I'm comfortable with it.
Do you want to do that, or should we adjourn it and
I'm okay.
go out? You're okay?
Yeah, sure.
Okay.
Okay.
Okay. Let's see. How do we need to proceed on this? I don't know. Tony, do you want to do this one, or?
So is this just quick? Is this going to change at found in items 1 through 5 of the staff report?
Yeah, I have to do that.
So
I know,
maybe I'm not ready for that.
No, when he said Tony, I'm thinking, sure, blame it on the new guy.
You're right. Okay. No. You're quite right. Okay. All right. This was my idea. All right. Here we go. Where's my cheat sheet here? Okay. Why? You'd think after I wouldn't need it anymore. All right. Okay. I move to approve the request for a variance set forth in item number 12. This decision is based on a review of the application, testimony of the applicant, testimony gathered during the public hearing, the results of site visits by board members, and in approving of this request, the board it makes the following findings. It's an area variance from Article 4 to 10-48 to allow the construction of a one-story detached garage measuring 24 by 24 to be located 6 feet from the rear yard boundary, where the required minimum setback is 10 feet. Whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by the granting of the area variance. The board finds that in this particular neighborhood, many homes have detached garages and sheds, and that there was no testimony suggesting that any undesirable change in the neighborhood would occur from this action. 2, whether the benefit sought by the applicant can be achieved by some other method feasible for the applicant to pursue other than an area variance. The board finds that while it would be possible to locate the garage in a location that would not require a variance, that this location would decrease the benefits sought by the applicant, namely a storage facility that would permit access to a gate and that would preserve the open space of their backyard. 3, whether the requested area variance is substantial. The required rear lot setback is 10 feet. The garage is going to be located 6 feet, so the variance amounts to 40%, which is somewhat substantial. 4, whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions of the neighborhood. The garage is going to replace an existing carport that's been there for many years without creating any difficulties, and there was no testimony suggesting any negative impact. 5, whether the alleged difficulty was self-created. Arguably, it is self-created, but that doesn't preclude granting the variance. So based on these findings, I move that the variance in item number 12 be granted. Okay. Moved and seconded. Any comments, questions, discussion? If not, all in favor of granting the variance?
Aye.
Aye. Opposed? Recusals? Okay, the variance is granted 7-0. Item 15, John and Laura Agard, 2 Marwood Drive. Variance to allow a proposed shed to be located 1 foot from the side lot line where 10 feet is required. It's a type 2 action. In your staff report, in your packet, there's a staff report recommending that this be approved. In the staff report, I would just make one correction under the application type. The area variance to allow a proposed accessory structure to be located 1 foot, where instead of 20 feet, that should be 10 feet. The typo that needs to be corrected. And it's also, the typo also occurs in number 3. Okay. Okay. Discussion? This seems very.
Looks reasonable to me.
Yeah. I mean, I think tucked away in that fence off in that corner, probably most people aren't going to even notice it.
No.
There was certainly no testimony to the contrary. Okay. Yeah, go for it.
I move that the board approve the request for an area variance set forth in item number 13. Decision is based on a review of the application, testimony of the applicant, testimony offered in public hearing, results of site visits by board members, and the staff report. In approving this variance, the board adopts as findings the determinations found in items 1 through 5 of the staff report.
Second.
Okay. Any discussion? If not, all in favor?
Aye.
Opposed? Recusals? Okay, approved, 7-0. Item 14, Stewart Shops, 85 Creek Road, a variance to allow the installation of an electronic message display sign in a BN district in which they are prohibited. It's an unlisted action, so I move the zoning board declare itself lead agency for purposes of the environmental review of item number 14.
Second.
All in favor?
Aye.
Aye.
Opposed? Recusals? I further move that the zoning board finds that the application at 85 Creek Road, based on information in the application and in the environmental assessment short form, finds that the proposed action will have no significant impact on the environment. Is there a second?
Second.
All in favor?
Aye.
Aye. Opposed? Recusals? Okay, on the motion itself, any discussion?
Oh, I know. It's getting late. I think we're getting tired.
Okay. Larry, do you want to do this one?
You know, there's an interesting part of the code that says they can only change the sign every 12 hours, not more than once every 12 hours. So you're not being able to go other than down might work.
Yeah, I know.
That was a nice try.
That 12, yeah, well, you know.
Very good.
Get what you can. Yeah. Here we go.
What number is that, 14?
It's 14.
Yeah.
I move that the board approve the request for a variance set forth in item number 14. This decision is based on a review of the application, testimony of the applicant, testimony offered in the public hearing, the results of site visits by board members, and the staff report. In approving this variance, the board adopts its findings and determinations found in items 1 through 5 of the staff report. So moved.
Second. Second.
Okay, motion to approve the sign variance for Stewart's. Any discussion, comments? If not, all in favor?
Aye.
Aye. Opposed? Recusals? Okay, approved, 7-1. Or 7-0, excuse me. All right. Item 15, Maria Balbo, 788 Main Street. 3 variances. To allow front yard setbacks of 4.8 feet and 0.7 feet along Main Street and Raymond Avenue respectively, where 5 feet is required. B, to allow a lot coverage of from 60 to 97%, where a maximum of 60% is permitted. And C, to permit an impervious surface coverage of 100%, where a maximum of 95% is permitted. It's a type 2 action, no environmental review is needed. The county has notified us that this is a matter of local concern. And in your packet, there's a staff report recommending that these variances be approved. Questions?
Yeah, with the lot coverage and impervious surface, were those, didn't they correct that, or was?
Well, he testified that the lot coverage was not 97%.
Okay.
That there was substantial parking lots. But it well may be more than the 60%. So we can phrase the variance to allow something between 60% and 97%. Otherwise, we're going to have to go back and measure it and come up with a specific number, which is not going to make any difference.
I can give you the number tomorrow for your information. That rapidly, I can do it.
If he did that, could you just insert that into the into the
Well,
variance?
Technically, the public hearing is closed.
Yeah, oh, I see.
Can say, though, is you have the plans before you from which you could determine what the lot coverage is, so that as long as the variance is consistent with the plans, you're covered in terms of the parameters of the variance.
Okay. Yeah,
Let's do that.
Insert that into the finding. Yes, no, that's, yeah. You know, okay, any other comments, questions? Okay. Let's see, Paul, you want to do this one?
Sure. I move that the board approve the request for an area variance set forth in item 15. The decision is based upon the review of the application, the testimony of the applicant, testimony offered in the public hearing, results of site visits by board members and the staff report. In approving the variance, the board adopts its findings and determinations found in items 1 through 5 of the staff report. Subject to the site plan submitted.
Okay. All right, second for that? Did someone second that?
I did.
Oh, okay, very good. Okay, any further discussion? If not, all in favor? Aye. Opposed, recusals, okay, approved, 7-0. Okay, that brings us to the end of our agenda. There's no further business before us. I move that we're adjourned.
Second.
Favor? Aye.
Aye.
Okay, thank you.
Louis, thank you.